Welcome to the Murphy, Sam, and Jodi After the Show podcast, and you can follow us on YouTube. Subscribe to our YouTube channel, actually, if you haven't had a chance to do that yet. Earlier this week, I think, Jodi, was in your Hollywood Outsider, you were talking about Taylor Sheridan, you know, the creator of Yellowstone, and how he's being sued by somebody who said, wait, you stole the idea for Yellowstone from me, right?
Right. Her name is Lauren. It was 2016 that she presented script to him about an idea that she had about a TV show. And after she presented it, this is her side of the story, she presented it, and then she was told that Mr. Sheridan is not open to TV projects at this time. That's what she's saying.
Yeah.
Yeah. And then it turns out that in the next thing you knew, he was producing Yellowstone, and she says it's very similar.
Yeah. Well, you know, what is interesting, I had the thought after you did that story just about, because it's a common thing. We hear about it all the time. It's a real thing, copyright infringement and stolen ideas and all those things that always seem to wind up, you know, in court.
That was my cookie recipe.
Right. Which, right. And, you know, Ed Sheeran, I guess, is also another recent example of that. But it made me curious because some of these, you wonder, it's so subjective when you talk about, okay, it's an idea. And people are inspired by ideas all the time to do things. Think about artists who grow up idolizing somebody, you know, in a generation before them, and so they tend to emulate styles and those kinds of things. And that's not really stealing; it's a style thing, you know. It's not unusual.
Inspiration.
And I'm sure it happens in the movie business too, where you have directors or screenplay writers or others who are so inspired by really famous directors that's where you get your creative juices from. And I'm not saying that's a license to steal whatsoever. I just see how it's human nature that actually can happen that way.
Yeah, what I always find amazing about that is how in court they can get down to the point of, yes, you did because
it's a creative process.
Because it's all out there. It's like, how can you nail that down?
Yeah, and I had the same question, so I went and I went and studied a handful of these, and I'm not a lawyer. These are just things that, you know, that I found that help. And so one of the big differences is many times these settlements are not decided, or these judgments are not decided on the actual idea stealing and copyright. It's usually breach of contract. And here's where the difference is. For example, in this particular case, and we don't know how this is going to play out because it's in the court system right now. But let's say that, you know, this person actually had signed a contract with Taylor Sheridan's production company or whomever, and that this was the agreement that they were going to work into, and then they turned it down. But then he takes and uses those ideas anyway. That would be considered breach of contract because you contracted for this idea, but then you broke the contract and you went and did it anyway. And that's different than the idea part, which many times doesn't succeed because certain ideas by copyright law can't be copyrighted, written. That's what it is. This is why I'm not a lawyer.
Copywrote.
They can't be copywritten at all.
Correct.
And for example, and this is new, I never heard about this before. Let's say like in a Yellowstone type situation, you write something where you've got mountains in the background and there's cows and it's sitting on a ranch. Well, you can't say, well, that was my idea because the basic theme in a setting, right, can apply to any show that is not copyrightable, you know, in any way, shape, or form.
It's a tricky situation, in my opinion, for someone who is a creative type to have to go pitch it to someone because you do give away your goods.
Yeah.
To pitch something, you have to give the goods.
Yeah.
The only example I can give you is recently I spoke on a panel of in our industry, in the audio industry, about mental health.
Yeah.
And before the panel, I was on some phone calls about the panel. Okay, the person who was leading it did some phone calls, and it was like, well, I would like for you to go in this direction. And she said, can you tell me a little bit about this? And I started to talk about it, and then I realized I'm going to tell you what I'm going to tell you without giving you the goods. I did not want to spill everything ahead of time. Not that I thought it would be stolen so much, but then again, some of my words were my words, and I wanted them to remain my words until I spoke them.
Yeah.
So that's a tricky spot for a person who is presenting something, some sort of content. You know, if you've got to pitch it to somebody, you've given it.
Yeah. Boy, you're right about that. Well, and that's why you sign confidentiality agreements and non-disclosure agreements and those kind of things. Obviously, you weren't going to do that on a panel, but But I think that's brilliant, Jodi, because people don't intentionally. This is another perfect example. You're talking to the panel ahead of time. Everybody's trying to get their ideas together.
You have to plan it a little bit. I mean, you do have to plan it.
Right. And so by the process of osmosis, people, again, don't. Something resonates, you like it, and you're unintentionally, potentially going to regurgitate that back out, right? And so
right. I didn't want those words to be spoken because it was a quote-ish sort of thing. I can't remember what it was now, but about the subject matter. I remember jotting it down saying, I'm going to say this. Mm-hmm. And I didn't want it to be out there before I said it.
Right.
That's all.
Yeah, I think it is a really slippery slope. And after reading up on some of this now, I guess in my head I always thought, well, this is pretty cut and dry. That doesn't sound like they stole that, or wow, that sounds like they stole that. But it's always more complicated than that. It's about the process in the background, and that's what the attorneys and the courts really have to work their way, through. And some of the things that stood out that I learned from this, I never heard this part of the story. So this is going back 50 years. George Harrison, and one of the famous, I guess, early copyright lawsuits that he had unintentionally and even admitted to unintentionally mimicking the rhythms and the melodies of a song called He's So Fine when he did the song My Sweet Lord, which was a number one hit. And the judge found that, he did copy that, and that even though it's not about it. What did they say? You can steal a song even without knowing that you did.
Sure.
He didn't realize that he did because it was, subconscious. And it was so close that, the jury thought that was a breach.
How can you?
But that's not intent. That's not intent, which is interesting to me because intent always comes to play in a criminal case.
Yeah. Well, so here's the other. This is what really made that one complex. This is the part of that story I've never heard.
This is a tricky law.
Yeah, he didn't wind up having to pay the full judgment because his business manager, George Harrison's business manager, had secretly bought the rights to that song.
Oh.
So
secretly behind George's back?
Yeah.
Because of that reason?
No, he didn't know. And so the court ruled again on a much lesser judgment.
Why would he have bought it?
And George Harrison wound up owning the song. His fine basically was buying the song.
Oh.
And
was that because he was being sued that the manager went out and bought the song?
See, and in that part, I don't know when he secretly bought the. But it was his business manager actually made it better for George in this particular case.
Okay. Maybe we'll find out in the Beatles movie when they do the George one.
But see, I've never heard that part. I've always heard that he was found guilty and he had to pay a fine.
Yeah.
Well, there was no fine.
Right. Well, no, there was a fine, but the fine led him to...
he's so fine.
To buy, I think, right. He either bought half the rights to the song or something like that. But because his manager actually was the one who wound up owning... That's really messed up.
Really screwed up.
And then the Blurred Lines one, Robin Thicke, if you remember that one from 10 years ago.
Got to give it up.
Which that's what, this was the Marvin Gaye estate, who then came back on the Ed Sheeran one. Two different scenarios, by the way. Yeah. And so they came back and say Blurred Lines clearly is an emulation of, Got to Give It Up by Marvin Gaye. And it wasn't just the suggestion of that. It's actually, this is what I read now, the interpretation of it. The difference between Ed Sheeran winning his case and Robin Thicke not winning his case was what they actually said up on the stand.
Yes.
So Robin Thicke basically said that, he had made a mistake, which was admitting guilt.
Yeah.
And I think that he had some interview somewhere, he had actually said, I was going for a Marvin Gaye vibe. And that statement in and of itself apparently is not enough to get a lawsuit won in the favor of the person who
good, because a lot of
actually
people are influenced by, like even Stevie Wonder was influenced by Earth, Wind, and Fire at one point, and then gave us what?
I think he said "I wish" is his, but and that's what I was talking about at the beginning of the podcast here. That it's really such a gray area because sometimes it's just inspiration, but again, you get into a courtroom scenario.
And
everything then becomes a legal technicality. So now the purpose of there's nothing, the jury, I guess you only have to prove to the jury one way or the other for them to make a decision. And if the person who's there said, I made a mistake, you're inferring guilt.
Admitted.
Right. And so, but that's not what Ed Sheeran did. Ed Sheeran actually did the opposite. His thing was, So that was for Thinking Out Loud, which I think they said sounds a little like Let's Get It On. Ed
What?
Sheeran-
I forgot about
yeah,
that.
remember Sam had done that one. That one went on for years, actually.
Yeah.
And
That is not to me the same.
it was
but-
tried and it was retried and it was retried, and finally the Supreme Court threw that one out. But Ed Sheeran's take on the stand basically was, he said, if this happens, I'm done, I'm stopping, meaning he was going to quit music, period. He did not implicate himself with anything. And that was a very long process of talking about, again, this vague gray area of influence and inspiration and all of those things. And the judgment for that essentially was that, and again, you'd have to go, I'm not a lawyer, so you'd have to go read the legal technicalities on this.
I don't want to get in the weeds anyway.
Right. Part of that came down to, the courts basically saying, okay, a copyright is what you put on paper, and that's what you wrote, and that's what you did. The copyright doesn't cover a vibe. It doesn't cover a feel. It doesn't cover anything other than what you actually registered with the Patent and Trade Office as a copyright. And again, I know I'm disclaiming this because I'm not a lawyer. This is just what I read. I found that really fascinating, and ultimately I just have a new appreciation now for where this goes, whether it's a frivolous lawsuit or not. And sometimes they're very unfair. Sometimes it's the right thing because somebody did steal something, but it's so much more complex than just listening to a piece of music or looking at a film clip of something that you're claiming, because it's so much deeper than that. It's about contracts and what were your agreements, and it's so complex. So it'll be interesting to see what happens with Taylor Sheridan on this one. These are just allegations. I don't know if it's been filed in court. I don't remember what you said in the story, if she was alleging or if she's actually
She was alleging and she was going to sue, and he had not made a comment. That was the last I had read.
Yeah.
He had not made a comment, which means he's probably lawyering up.
Yeah. So we'll see that. We'll see where that goes. It's just it's such a, I shouldn't say blurred line, but that's kind of what it is between art and science, right?
Before we wrap up
Data.
here, do you know the story about just the opposite of this, Olivia Rodrigo and Elvis Costello?
No.
Now, Olivia Rodrigo, on her album Sour, she had the song Brutal. And when you listen to the song, it's like, oh, wait, that's Elvis Costello's Pump It Up. And so everybody pointed it out, and they went to Elvis. What are you going to do about it? What are you going to do about it? She took your song. What are you going to do about it?
And
he dismissed the idea. He said, it's ludicrous and too silly to talk about. Musical borrowing is a natural part of rock and roll.
Good for him.
Yeah, and that's that whole borrowing and you're in the influence thing. And sometimes that's going to depend on if Elvis Costello had felt differently, it would have wound up in court. Yeah.
Yeah. That's why we didn't hear about that story. So thanks for adding that.
Yeah.